that your legal representative is appointed, prepared and ready to proceed with trial lies with you. Now, I just want to know from you, what would you have done should we have started on the 21st of July without a legal representative?
Firstly, when I respond, I applied for legal aid because I'm not in position. I don't have funds to get appoint my private attorney.
Abuya impendulo ethi maphinde ndifake application kwa-legal aid. Ndayenza i-application.
Was a response to the effect that I must again apply for legal aid, and I complied with that.
Ndaqala ukuba ibuye impendulo isithi isicelo sami asiphumeleli.
Well, that applies to the news that my application has not been approved.
Isizathu kwathani ndikwazi ukufumana i-legal aid representative ngoba xa kubonwa isimo sami semali andinayo imali, ndaxaba kanjani ukuba kaloku kufuneka uya kwi-legal aid representation ngenxa yokuba imali ungenayo.
Now, I was surprised to hear the reason for my application being turned down. Looking at my financial position, was I do not have funds or I do not have funds. Hence, I went and approached the legal aid board for assistance for my legal representation.
So umuntu obengincedisa kuyo yonke le communication yale nto, one things into yoba uzobe aphinde adibane i-advocate Montloni uba abanakundithatha back na andile.
Now, the person who was assisting me in all these processes informed me that he or she would get a consultation with Mr. Montloni and engage with him to see as to whether would it be possible for him to take me back as described or not.
Yabuya impendulo endinomncedisayo isithi akakwazi ukuyifumana u-advocate Montloni. Yaye futhi uyacingela into yoba uxakeke kakhulu uba uphethe elityala lika-accused number 1.
I then got a response from the person who was assisting me to the effect that she did not get the hold of advocate Montloni. He believes that the advocate is too engaged and he's also now concerned and he's representing number 1. He was trying to get hold of it.
Loo nto leyo ke i-communication kuyo yonke le ithatha ixesha ukuba izofika kum iyaphela inyanga kuphela inyanga ezibeni salinde impendulo.
Now, my lady, this form of communication takes a bit of time before I can be appraised as to what is the position. A month or 2 months lapses before I can get to know where we stand with regard to this issue.
Kwezi veki ziphelayo bengisanda kufumana into endikhumbuzayo uba i-legal aid representative andinayo. Ngoko makuzame kume ngenyawo ngifune iqhubeke ngoba ngibethekile noma ngi-aphile.
Now, recently, that's when I got update to say, remember you only have legal representation, so you must take steps. Or what? Was that implying that I must appeal for that prior decision?
Ngoku phezu kwalomisa ukuba mangenze loo aphile ukulungiselela-ke i-21st kaJulayi.
Now, currently I'm in that position where now I'm trying to get this appeal lodged so that we prepare for that day of the 21st of July.
Mr. Sekelene, it's very important that you understand that we are already at the 17th of June 2025. And I presume that the preparation of your case will be extensive. And it will be to your detriment and your prejudice should you appoint counsel or legal representation at a very late stage. Do you understand that?
Yeah, this is something out. I understand that.
And then also, of course, this court is faced with Section 342A of the Criminal Procedure Act, Act 51 of 1977. Now, Section 342A of the Criminal Procedure Act reads that a court before which criminal proceedings are pending shall, not may, must, shall investigate any delays in the completion of proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused, or his or her legal advisor, and the state witnesses, the state or any witnesses in the case.
Section 342A, because
you must be very careful that your conduct in obtaining legal representation does not cause an undue, unreasonable delay that must be investigated by this court and that must be ruled upon by this court. Now, I thank you for your explanation that you've just given in your endeavours to obtain legal representation. I will just hear from Ms. Kruger from the Legal Aid South Africa as to what the situation with your legal aid application is. You may be seated in the meantime. Thank you, Mr. Sikeleni. Thank you, sir. Thank you, Ms. Kruger.
Thank you, my lady. My lady, with the previous appearance on the, was it the 13th of January, I personally indicated to Mr. Sikeleni that his legal aid application was refused and that we must proceed with an appeal process, or he must proceed to give us instructions to proceed with the appeal against the refusal of legal aid.
Was that in January 2025 already?
Indeed, so my
That he was informed that his application for legal aid was denied?
Indeed, so my lady. I remember I spoke to him on that day and explained to him what documentation we will need. And then in March, I received, I sent an email where I confirmed, sorry my lady, I had it now with me, where he informed us that he does not wish to proceed with the appeal against the refusal of legal aid, but that he would approach accused number one's legal representative to see if they can assist him, my lady. Now my lady, if we don't have instructions to proceed with an appeal against the refusal of legal aid, I cannot force the person to proceed on that basis, and therefore no further action or steps were taken. I do know that I sent an email, I think it was in July, my lady, I see I didn't print it for my file today, where I confirmed the position to Mr. Sikeleni.
July is still May.
Yes, thank you, my lady. I will send it later to your registrar. I didn't print it and put it on my file, but that was the position, my lady. So currently we don't have instructions to proceed with an appeal against the refusal of legal aid. I heard from Mr. Motlamu this morning that Mr. Sikeleni should proceed with that process, my lady. So I will speak to him after this court appearance, just to make sure that we can then proceed with the appeal against the refusal of legal aid, my lady. That is from my side what I can put on record, my lady.
Was Mr. Sikeleni properly informed as to the process to appeal?
Yes, my lady.
And what was expected of him?
Yes, my lady. Yes.
And that was either in January or March?
Yes, my lady. I specifically spoke to him personally, and I also remember I spoke to one of his sons telephonically at one stage, also to say that you must please make sure that your father attend to the necessary documentation so that we can proceed with the appeal against the refusal. And then thereafter, the further communication we received was that he will approach accused number one's legal representation, my lady. So yes, that was by myself explained to him as well, my lady.
Mr. Interpreter, apologies. Thank you.
Message that I received from Mr. Sikeleni. I see the date is not indicated here, but I will also, I think it's the only copy that I have in my file, so I can provide it after the court proceedings to the court, where he indicated that I'm getting a new suggestion that I'm asking accused number one's lawyer. So at this moment, let's disregard these LA1 forms, my lady. So
Good.
here it is.
I will then enter that into evidence as Exhibit A.
Thank you, my lady.
You can just make the complete document with the date and everything available to me later.
Ukifunda hapa hii WhatsApp message tunaendelea na yoba usana kama ukubana mweli kama number 1 and then kwa hizi ile za forms zikugadi uki ile the WhatsApp is ile uzaongeza ukati ile wasikubile hapo.
Mr. Sikeleni, I'm gravely concerned about this. So, what is your decision now? Are you going to appeal the decision of Legal Aid South Africa, or are you going to appoint legal representation on private mandate? Thank you. Ms. Kruger, how long is an appeal of this nature then going to be?
My lady, yes. If we get all the documentation, I presume I will be able to submit to our national office this week still. And then we should then be able to get, usually they sit, I think it's the first Wednesday of the month, my lady. So we should be able to get a result pretty fast, my lady. So if I can just get the necessary documentation from Mr. Sikeleni, but I will speak to him now after the court appearance, my lady, to make sure that I submit our appeal already, or recommendation rather, by the end of this week, my lady.
So the time frame we are looking at is how many weeks?
Should have a result in the first week of July, my lady. But yes.
And thereafter consultations must still be finalized.
Yes, my lady. Yes.
And what I gather from this case, it's extensive.
Yes, my lady.
Will that be done before the 21st of July? Is that possible?
I think so, my lady. I'm not, yes. Let me not say a definitely yes, my lady. But
I will have to have a definite something. Either you will not be able to do that, or you will be able to do that. Why I'm asking this is you can look at this court. There are so many role players that are affected. The administration of justice is affected. So I can't go on a maybe. We must either start on the 21st of July, or we must make alternative arrangements.
my lady, we will be able. Oh,
To have place on record, the document is more or less 5,000 pages. That is not the footage and the tracker reports.
Sorry, where did that come from? The 5,000 pages? Who's from you? Yeah, but who's so impressed with that? In the gallery. Somebody in the gallery is very impressed with that. Thank you. Thank you. 5,000 pages to be prepared, to be consulted on.
my lady, if we can get the documents already by this week, which I will press upon Mr. Sikeleni, the importance thereof once again. My lady, I think we will be able to proceed on the 21st of July, my lady.
Think. No, definite undertaking. Apologies for putting you on the spot, but I can't work with this uncertainty, because also the extra added issue is that I and everybody will be taken out of circulation for at least a term, and whilst I could have attended to other cases,
No, I understand.
we are struggling with a shortage of judges. Our roles are very, very high, so we cannot afford that.
No, I understand that, my lady. My lady, all that I can say is that from our side, we will definitely endeavour to finalise the processes as soon as possible, my lady. We can even, if it need be, we can ask for the committee to adjourn or convene rather earlier, my lady. So we from our side, we will be able to be ready, my lady. Yes.
Thank you for your commitment. Apologies. Apologies, Ms. Krieger. Then we have the added issue. What will happen if his appeal is denied?
My lady, based on the information that we have, I don't think that will happen, my lady.
Thank you.
Thank you.
Thank you, Mr. Sekeleni. Any questions from your side? Anything that the court can assist you with that you do not have clarity on by now?
No, I do not have any questions at this stage.
Thank you, Mr. Sekeleni. You may be seated. Mr. Mutaung, your name was mentioned as a potential legal representative, but what is your stance on that? Are you willing to take a mandate in case of a crisis?
In case of, thank you, my lady. In case of crisis, I am, my lady.
And then you are also confronted with a maybe conflict of interest.
There is no potential conflict of
Interest there will not be. Good. So you can sort of be a standby for the Legal Aid Board. Will that be possible?
That's possible, my lady.
And yes, so Ms. Kruger, you and Mr. Mutlaung will then liaise
Yes, my lady.
on this if there is an issue. Thank you. Thank you. Thank you. This brings me to accused number 6. The matter was withdrawn. The case was withdrawn against accused number 5. Accused number 6, Mr. Theo Franz Magotsa. Mr. Magotsa. Your legal representative seems to be Mr. Reineke from Legal Aid South Africa. Are you satisfied that he was appointed as your legal representative and that he will be representing you for the duration of the trial?
I confirm that position to be correct, madam.
And you so satisfied?
Yes, I will speak to court to say I'm satisfied.
Thank you for that, Mr. Magotsa. You may be seated, Mr. Reineke.
Thank you, lady. As I've indicated before, I'm appealing for accused numbers 2, 3, and 6.
Yes.
And your ladyship raised the question with Ms. Kruger about the preparation part of accused number 4. I have spent 3 days, full days, with Ms. Bester, just to make sure that I have the full docket. I can honestly place on record that if someone is taking instructions only now, with the limited time left, if that person is ready, it would be barely so. I've seen the docket. I've unfortunately last worked on the docket end of February, beginning of March, when my mandate was terminated. So I haven't worked on it again. To look at the 21st of July, next week I'm with your lady. I'm currently busy in Welkom with your sister Gwynzai. Next week I'm with your ladyship with the party of Natalie Mary Smith. The week thereafter I'm in Johannesburg for a seminar, and the week thereafter I'm not available. That leaves me only a week left to prepare, and there's no way that I will be ready. I understand amongst some of my colleagues that there might be other issues that would indicate, but I thought it prudent to inform your leadership now that I do not believe that on the 21st of July this matter would be able to kick off.
Thank you for the clarity, Mr. Reyneke. I appreciate that. Thank you. Thank you. That brings me to accused number 7, Mr. Thabo Bester, who is appearing on his behalf. Thank you, Ms. Moela. You ready and prepared to proceed?
No, my lady, there is no exception when we entered the proceedings in July last year. Yes.
When did you receive instructions?
In July last
July last year.
Yes, 2024.
Yes.
Yes. If I may address the leadership in terms of what has caused our delay, in short, is that, or what has caused the delay in the readiness, is that there is an interlocutory application that is pending dealing with the section 35 of accused number 7 with the applicant in those proceedings. What he is essentially seeking is that he received conducive consultation, like a regime, in the sense that there are video footages in a USB that need to be viewed in that particular consultation. In one of the prayers, or what he's seeking is that he be granted access, his legal representatives be granted access to, or be allowed to have access to their device in that consultation, and also be allowed to have such for that purpose. And the other conducive environment is one in that we consulted a booth where we were separated by a glass window, and we consulted telephonically. So it might have an impact on his privacy. So that's what is also addressed in that application. So the status of that application is that it's still pending. So it was done in 2 parts, obviously flowing from the directive from the court. Firstly, it was before the court in July, and it was then sent to the civil court to decide whether the nature of the complaint in that application are either civil or criminal in nature, and not to deal with the substantive merit. And we appeared on the 28th of November before DJP.
Mbele.
Yes, and the matter was reserved, and the judgment was handed down. I'm just looking at my notes.
I think it's January.
21 Feb. In January we appeared, it was not handed down as yet. So that was handed down, and the accused number 7 then appealed simultaneously directly to the Constitutional Court, and with the conditional leave before the DJP. So the Constitutional Court handed down its order and refused direct access. So that appeal is pending before Justice Mbele. And we've been given a provisional, not a provisional date, but we've been given the availability of the 21st of July to count. But we said we'll wait for the outcome of today, whether to confirm whether we can be able to argue that. So once that is decided, my lady, whether this is civil or whether the complaints are civil or criminal in nature, a determination will be made as to which forum will hear the substantive merit. And while the substantive merit ahead, we can then speak about the readiness of this matter.
So you were given a provisional date by the Office of Acting Judge President Mbele for an application for leave to appeal on that issue on the 21st of July.
Yes. That is in a nutshell in terms of where we find ourselves.
Good. So, but you have been properly instructed and you undertake the mandate for the duration of the trial should the matter commence.
Should that, not on the 21st of July, my lady, because if I was to interpret the question posed by a lady.
Oh, but I hear what you're saying.
Yes.
You will not be ready and prepared because you couldn't have concluded the consultation due to the issues raised in the Mbele judgment.
Yes, in the main application, the Mbele judgment, obviously it's one.
Yes,
The
yes,
same thing, but ultimately is the substantive merit of what is still pending.
yes.
It's going to resolve whether the applicant will be afforded that of which is seeking. So
Good.
we have not been able to consult substantively. Obviously, you can do certain consultations that are not going to the merits of the case, because when you
Yes.
do the substantive merits, you need privacy to be sort of like assured.
Thank you.
Yes.
Thank you for that, Ms. Muela.
That's the correct.
Thank you. Mr. Bester, you are satisfied with the legal representation of your counsel and you confirm what he has just indicated to the court.
Yes, sir.
Thank you. Thank you. You may be seated. Then we go to accused number 8.
May I address you regarding accused number 7?
Yes, you're welcome.
Thank you. My lady, in July when we appeared in court and when Mr. Advocate Moyenda came on board, it was an application that was filed and the judge president, who was the presiding judge, said it was not properly before the court. And according to me, because we made use of the private counsel, nothing was done yet, and in the end it was the respondent who set the matter down. And that is when the matter was heard, I think on the 28th of November. So that is a delay that I am of the opinion that was caused by accused number 7's legal representatives. Then further, my lady, there's a huge difference. The footage is not the alpha and the omega. There are really 5,000 pages that they can proceed with before we come to the footage. But there's a difference if they had consultations about the merits as from the 13th of January, or if they didn't even try to do that. And I would like to know that, my lady. Did they have consultations regarding the merits in this matter as from before?
Yes, but have you read the judgment of my sister Mbele?
I did.
Good. So in that judgment, the whole issue is about his access to a laptop and I think 7 hours of consultation. So there are many issues about the consultation that has to be resolved first, as I understand the judgment, before there can be proper and effective consultations. That according to this case. So I don't know if Mr. Muhela wants to answer this question, sir. Let me just hear from you.
My lady, if I may, it's difficult to have a 7-hour consultation in any event with any person. You can't concentrate.
Well, that's what you say.
Yeah.
But you don't know what Mr. Bester's capabilities
He's maybe
and Mr.
capable of
Muhela's
doing it. I know.
capabilities is. Yes.
But if you make use of the time, say for instance 2 hours per day, you could at least start with a consultation. And I think that's essential. We must know, did they at least start with a consultation?
I'm willing to answer that, sir. Sorry, Ms. Lester.
Because, sorry, Ms. Moya, I asked Counsel to establish if there was indeed consultations, because I must inform the court about that. And according to that, Mr. Mohela, as from January up until Friday, he visited Mr. Bester on 2 occasions, and Mrs. Reed on 6 occasions. So it appears to me that there was not even an effort to start with that.
Thank you. Thank you for that. Mr. Moela.
And the court, please, my lady. I want to answer that. I have 2 answers to that. Firstly, that's premature to be engaging in this debate, because it's something that is pending. What the state is posing or arguing is something that they need to argue in that particular application, because that's exactly their answer to their application. So the court needs to make a determination. As I indicated, the issue is not only about the video footage, but there are other ancillary issues as well, including the number of hours that the accuser had requested, including the environment itself, in-person consultation as opposed to telephonic consultation, and other issues as well that, in this view, would reasonably, he has reasonable apprehension that it will affect his fair trial right, this certain treatment that he's complaining about, which is not the main, but it's ancillary to that application. Because those are the things that need to be dealt in that particular application. In respect of consultation, I've said to you already that we have indeed consulted, but not in terms of the substantive merit of this case. That application itself was a product of consultation, and other applications as well was a product of consultation. Some of the consultation, when given an opportunity, we are able to conduct them here in court if we finish early. But that is not enough to be ready for the trial.
Ms. Miller, I know that the litigation is pending on the issue, but I, for one, do not see any obstacle why consultations, interim consultations cannot occur. And then after the issue of the pending litigation has been resolved, so that you are ready to proceed. So just be vigilant of that you do not sit on your hands, and then when judgment in what direction or whatever is going to follow, that you are going to be caught off guard. There's no reason why you can't go to the prison and consult in the meantime. But I hear what you're saying, but just be vigilant that this is not a cause for an unreasonable delay. You as an officer of the court must be committed to the expedition of this court. So you've heard, I explained section 3428 to Mr. Sekeleni, and if you want to, I can explain that again to Mr. Bester. Not taking away his right in terms of section 34 of the Constitution to appeal the judgment of my system. Good.
Yes, I just want to confirm, my lady, I am committed to the expedited hearing. That's why one of the things that we did was to try to approach the Constitutional Court on a direct access so that we can expedite the proceedings.
Yes, thank you very much for that.
Thank
you. Thank you. Mr. Moyo, Zono Boniface Moyo.
Please do a seat, my lady,
Is it accused number 2, Mr. DePaul?
Yes, ma'am.
Is he not feeling well?
Seems like he's in pain now.
Mr. DePaul, can we be of assistance to you?
Just after the court pay of assistance, if you're continuing.
What do you mean?
Okay, what about that? Can I be provided with water money?
Of course.
But I hope you don't.
His legal representative, Mr. Ranneke, do you want to give an instruction? Thank you. I just want to know if he is well and able to proceed with the proceedings.
No, just do my best.
Thank you.
It seems he's starting to breathe. May I ask that we just take a short adjournment?
The board adjourns for a few minutes. If necessary, let us get the necessary emergency services.
All rise.
Thank you. Board adjourns for a few minutes.
Medical condition.